Welcome to Women in Law, the show where we explore the stories of the women who challenged the legal system and changed it forever. Today, we'll travel back to the 19th century to meet a woman who dared to ask a radical question. Why can't a woman practice law? Her name was Myra Bradwell, publisher, legal thinker, and one of the first women to fight for the right to join the bar. Let's hear her story. Hi, Mrs. Bradwell.
Hello.
So, I heard you passed the Illinois bar exam, yet you were denied a license. What reasons did the court give you?
Well, because I was a woman. More precisely, a married woman.
How did they justify it?
They said that my identity was tied to that of my husband's, that the natural sphere of a woman was at home.
Mrs. Bradwell, the law does not permit married women to practice law. Your duties belong to your household.
But I studied law and I passed the examination. Is competence suddenly erased by marriage?
The profession requires independence. Tradition cannot be overturned lightly.
Then tradition is standing in the way of justice.
The court must preserve precedent.
And then who preserves fairness? If the Constitution protects citizens' rights, then it must protect mine as well.
You may appeal, but the result may not turn well.
Maybe not today, but someday a woman will be in court and no one will question her right to be there.
After Illinois denied your license, you didn't stop. You took your case all the way to United States Supreme Court. Why?
Because the question meant bigger than Illinois. If citizenship meant equal protection under the Constitution, then the Constitution had to include women.
So, you believed that 14th Amendment protected your right to exercise law.
I believed it protected my rights as a citizen, and if the Constitution excluded women from its promises, then the nation had to confront that openly.
So, what do you remember the most about that appeal?
The silence before the decision, the feeling that history was listening.
So, they are arguing our argument now. We made it clear that the 14th Amendment protects your privileges as a citizen.
Good. Citizenship means participation, not limitation.
Some of the justices fear redefining the tradition.
Tradition has never been a sufficient reason to deny justice.
If they rule against us, the states may be justified in excluding women from professions.
The exclusion will be undeniable, written plainly for the whole country to see.
You see how historic this moment is?
Yes. Today it will decide my case, but the future will decide whether they were correct.
The court ruled against you.
Yes, they did.
Does it feel like the end?
No, actually, it felt like clarity. When injustice is spoken out loud, it's much harder to defend.
And years later, Illinois granted you your license.
The law resisted, but it did not remain still.
Mrs. Bradwell, I bring you words from the Supreme Court of Illinois. The court has voted to grant you permission to the Illinois bar, retroactively, as from your original petition.
Retroactively, huh? So the law has finally caught up.
Your competence were never in question.
No, they were definitely in question once, publicly and formally.
Times have changed, Mrs. Bradwell.
I'd say people have changed them. I imagine this must feel like a victory. It feels quiet. The real victory was never mine alone.
Today, thousands of women practice law without question.
Yes, because history does what it always does. It moves, slowly, but surely towards fairness. Rights are not granted because they are convenient. They are secured because someone insisted that they belong to everyone.
So, thank you so much, Myra Bradwell, for our marvelous interview.
Thank you for having me.
This has been Women in Law, because history is not only written by those who win, but by those who refuse to stop arguing for justice. Stay tuned for the next